Welcome to the Ramon Valley Democratic Club. My name is Brody Hill. I serve as president. Rick Adler, our vice president, is here, as well as our board member, Cecilia Manalga, who is our Zoom administrator and the chair for volunteer activism for our county's Democratic Party. So welcome to everyone. Many of our members live in Danville or San Ramon, but tonight we have attendees from all over Contra Costa County and a few from Alameda, and we found out we have somebody from Monterey and somebody from the state of Virginia. So thank you for joining us. The Supreme Court has been in the news a great deal. That is the reason we are so pleased to bring you an outstanding professor who specializes in the Constitution and how well the Supreme Court upholds, or perhaps doesn't uphold, our constitutional rights. Dr. Erwin Chemerinsky, our honored speaker, became the Dean of the UC Berkeley School of Law in 2017 when he joined the faculty as the Jesse H. Schilper Distinguished Professor of Law. Before that, from 2008 to 2017, he was at UC Irvine School of Law as the founding head and also a Distinguished Professor of Law. He has also taught law at Duke University and the University of Southern California Law School. His law degree is from Harvard University. And he's written about 12 books, which I did know, and they have some really amazing titles. I wanted to give you just a few. In 2010, The Conservative Assault on the Constitution. 2014, The Case Against the Supreme Court. 2017, Free Speech on Campus. 2020, The Religion Clauses, the case for separating church and state. And of course, in 2021, Presumed Guilty, how the Supreme Court empowered the police and subverted civil rights. I bought mine at Rakestraw, our local Danville bookstore. The book is wonderful, it's well organized, it's easy to read, and it's an eye opener. And I can highly recommend it. I hope everyone gets a copy and reads it. So thank you, Dr. Chemerinsky, for being here tonight. We are very honored.
Thank you for the kind introduction, and thank you for the plug for my book. It's really an honor and a pleasure to get to talk with you. This is a momentous time in the United States Supreme Court. What I want to do is talk about the current court, what it's likely to mean for all of our rights, and then talk about the court for the foreseeable future. I'm not sure what you had in mind, but if I talk for like 40, 45 minutes and 15, 20 minutes for questions, does that fit okay for you?
That sounds good, yes.
Okay. Let me make 3 points then in talking about the Supreme Court. First, the current court is the culmination over a half-century effort by conservatives to create a staunch conservative majority on the Supreme Court. In 1968, Richard Nixon ran for president, largely against the liberalism of the Warren Court. He said if elected, he would appoint strict constructionists committed to law and order. Nixon was elected, of course, and he appointed 4 justices within the first 2 years of his presidency. In January 1981, Ronald Reagan was inaugurated as president. And he said explicitly that one of his goals was to put conservatives on the Supreme Court and the lower federal courts. He did just that. Reagan was able to put 3 justices on the court and also elevate William Rehnquist from Associate Justice to Chief Justice. When Donald Trump ran for president in 2016, he said he was going to appoint justices committed to overruling Roe versus Wade. And he was able to appoint 3 justices. He picked 3 of the most conservative federal court of appeals judges in the country for the United States Supreme Court. The result is that we now have 6 conservative justices, all appointed by Republican presidents, and 3 liberal justices appointed by Democratic presidents. That's unique in American history. Until recently, we had liberal justices appointed by Republican presidents. Think of John Paul Stevens or David Souter. And we've had conservative justices appointed by Democratic presidents, Byron White, or before that, Felix Frankfurter. But now the ideology of the justices perfectly corresponds to the political party of the president who appointed them. I usually think of ideology as a continuum from the far right to the far left. And I think of the American people overall as a little bit left of center, maybe sometimes a little bit right of center. But 5 of the justices on the current court are very far to the right on the ideological continuum. Thomas, Alito, Gorsuch, Kavanaugh, and Barrett. They're as conservative as any justices who have served on the United States Supreme Court. This is the most conservative majority that there's been since the mid-1930s. Chief Justice John Roberts is also right of center, though not as conservative as those 5. But no, Roberts' vote is no longer necessary for a conservative result. The 5 most conservative justices, Thomas, Alito, Gorsuch, Kavanaugh, and Barrett, can act without Roberts joining them. And then there are 3 liberal justices. 2 I think of as more moderate liberals, Stephen Breyer, who announced his resignation yesterday, and I'll talk about more detail later, and Elena Kagan. And I think there's 1 staunch liberal justice, that's Sonia Sotomayor. There were 2 until Justice Ginsburg died. How did we get here? How do we end up with such a conservative Supreme Court? Let me give a couple of statistics. Between 1960 and 2020, there were 32 years with Republican presidents and 28 years with Democratic presidents. Almost even. In fact, in 2024, we'll have had 32 years with Republican presidents and 32 years with Democratic presidents. But between 1960 and 2020, Republican presidents appointed 15 justices and Democratic presidents appointed only 8 justices to the Supreme Court. That's almost a 2-to-1 difference. Or another statistic that I find particularly startling. As I mentioned, as you know, Donald Trump was able to appoint 3 justices to the Supreme Court in his 4 years as president. If you look at the last 3 Democratic presidents, Jimmy Carter, Bill Clinton, Barack Obama, they served a combined 20 years in the White House. But in those 20 years, they appointed only 4 justices to the Supreme Court. Some of this is the accident of timing for when vacancies occurred. Some of this is how the Republicans blocked the consideration of Merrick Garland, rushed through the confirmation of Amy Coney Barrett. But it does explain the court that we have. And when we think about the Supreme Court this year, in the foreseeable future, is the court we're likely to continue to have. Well, let me then move to the second part of my remarks and talk about what's it going to mean to have such a conservative court. As I said, it is the most conservative court since the 1930s. This is Justice Amy Coney Barrett's first full term on the court. What's likely to affect on all of our lives? I think that this year is going to be one of the most momentous in recent times, perhaps the most momentous since I became a law professor 42 years ago. Let me talk about the issues that are before the Supreme Court right now and what they're likely to mean. I have to start with abortion. As everyone knows, in 1973, in Roe versus Wade, the Supreme Court held that women have the right to choose whether to terminate their pregnancies up to the point of viability, the time at which the fetus can survive outside the womb. In Planned Parenthood versus Casey in 1992, the Supreme Court reaffirmed Roe versus Wade and held that states cannot prohibit abortions before viability. Science and medicine tell us viability is about the 23rd or 24th week of pregnancy. There have been 2 matters concerning abortion this year before the Supreme Court. One involved a Texas law that prohibits abortion after the 6th week of pregnancy. Or, to be more precise, it's 6 weeks after a woman's last menstrual period, Many women don't know that they're pregnant at this stage. The Texas law is clearly unconstitutional under Roe versus Wade and Planned Parenthood versus Casey. Those decisions mean a woman has a right to choose an abortion to the 23rd or 24th week of pregnancy. Texas enforces this law through an unusual mechanism. Instead of having the Attorney General or a district attorney enforce the law, it's enforced by private civil suits. If a doctor performs an abortion, if anyone aids or abets an abortion, they can be sued for $10,000. It should not matter how the law is enforced. The law is unconstitutional. It doesn't become constitutional because it's enforced by civil suits rather than criminal prosecutions. This should be a very easy case. The federal district court in Texas issued a preliminary injunction. The conservative United States Court of Appeals for the Fifth Circuit reversed, and it went to the Supreme Court on September 1st, with the justice asked to issue a preliminary injunction. The justices voted 5-4 against the preliminary injunction. The 5 in the majority, Thomas, Alito, Gorsuch, Kavanaugh, and Barrett. Chief Justice Roberts, along with Justice Breyer, Sotomayor, and Kagan, dissented. We're together tonight on January 27th. The Texas law prohibiting abortions to the 6th week of pregnancy has been in effect for almost 5 months now. The law is clearly and blatantly unconstitutional, and yet the Supreme Court didn't enjoin it. The only way to challenge the Texas law would be for somebody to get sued under it, like a doctor who's performing an abortion, and then argue that the law is unconstitutional as a defense. After the Supreme Court denied review on September 1st, the United States government filed a lawsuit against Texas. The United States government said it was suing on behalf of the rights of women in Texas. The United States government also said it was suing to enforce the United States Constitution. A federal district court judge in Texas said the United States could sue and granted a preliminary injunction. The United States Court of Appeals for the Fifth Circuit reversed, and it went to the Supreme Court. And on December 10th, the Supreme Court ruled that state officers can be sued for an injunction only if they play a role in enforcing the law. And if no state officer plays a role in enforcing the law, none can be sued for an injunction. This is enormously disturbing with regard to abortion rights and other constitutional rights. Imagine now Arkansas adopts a law that says anyone who performs a same-sex wedding can be sued and is liable for $100,000. State officials play no role in enforcing that law. There's no way to get a preliminary injunction. The only possibility for some courageous wedding officiant to violate the law and be sued and argue as a defense that it's unconstitutional. Or why couldn't a state pass a law that says anyone who criticizes the governor of the state is liable for $1 million? Clearly, the law is unconstitutional, but the Supreme Court, in its haste to approve abortion laws, is allowing such a mechanism to stand. There's also another abortion matter before the Supreme Court. It's Dobbs versus Jackson Women's Health Organization. It was argued on December 1st. It involves a Mississippi law that prohibits abortions after the 15th week of pregnancy. This, too, is clearly unconstitutional because Roe, Casey protect a right to abortion up until the 23rd or 24th week of pregnancy. I listened to the oral arguments in the Supreme Court, and I have no doubt that the Supreme Court will have 6 votes to uphold the Mississippi law. Now, I think Chief Justice Roberts would like to uphold the Mississippi law without expressing any view about laws that prohibit abortion even earlier in pregnancy, like the Texas law that prohibits abortions at the 6th week of pregnancy, or the Alabama law that prohibits abortions from the moment of conception. But my sense in the oral argument is that 5 justices, Thomas, Alito, Gorsuch, Kavanaugh, and Barrett, want to overrule Roe versus Wade and completely eliminate constitutional protection for abortion. As you might have read in the papers, Justice Amy Coney Barrett said at the oral argument twice, there's no burden on women's rights by outlawing all abortions. They can just give birth and put the child up for adoption. Of course, this then forces women to be exactly what they didn't want to be when they're seeking abortion, mothers, and ignores the enormous burdens of an unwanted pregnancy. But my prediction at this point is, at the very least, the Supreme Court is going to uphold the Mississippi law and allow states to prohibit abortion after the 15th week of pregnancy. And that will overrule a key part of Roe, that women have a right to abortion until viability. But if I were a betting person, I think the court's going to completely overrule Roe versus Wade. What's that going to mean? Well, in some states, at least for now, abortion will remain legal. In California, Illinois, New York, abortion will remain legal. Women in states where abortion is illegal, who have money, will be able to travel to states where abortion is legal. I would estimate over half the states will prohibit all or virtually all abortions. But poor women, teenagers, will be forced to the choice that occurred before Roe of an unwanted child or an unsafe back alley abortion. And I intentionally chose to say for now, because I predict that as soon as there's a Republican president and a Republican Congress, they will try to pass a law nationally outlawing all abortions and preempting the ability of any state to allow abortions. So as soon as later this year, likely as soon as the end of June, I think the Supreme Court is going to say states can prohibit all abortions. Before New York became the first state to legalize abortion in this country in the 1960s, 25% of the abortions in England were performed on American women. It wasn't poor women going to England for abortions. And so I think what we're going to see is efforts in states like California to try to create organizations and provide resources for women in other states where abortion is illegal to be able to come into the state. But that action will produce a reaction. I predict that states will adopt laws prohibiting women from leaving the state for purpose of getting abortion. And that's where the next wave of litigation will be. The second area with regard to what the Supreme Court's likely to do and what it will mean concerns gun rights. From 1791, when the Second Amendment was adopted, until June of 2008, not one federal, state, or local gun regulation was struck down by the Supreme Court. From 1791 until 2008, not one gun regulation was ever found to violate the Second Amendment. There were a handful of Supreme Court cases that were dealing with the Second Amendment, and the court in them always said, the Second Amendment means what it says. It's about a right to have guns for the purpose of militia service. But in June 2008, the Supreme Court decided District of Columbia versus Heller. There, the Supreme Court held that the Second Amendment protects the right of people to have guns in their homes for the sake of security. The court didn't go any further than that. But there's a case now before the Supreme Court, New York Rifle and Pistol Association versus Bruin, that involves the right to have guns outside the home. A New York law that was adopted over 100 years ago prohibits people from having concealed weapons in public unless they have a concealed weapons permit. A concealed weapons permit requires that a person show a safety need for it. Challengers in New York argued that this law violates the Second Amendment. The federal district court upheld the New York law. The Federal Court of Appeals upheld the New York law. The Supreme Court granted review, was heard on November 3rd. My strong sense from the oral argument is that the Supreme Court's going to declare the New York law unconstitutional. I predict the Supreme Court's going to say there is a right of people to have guns outside the home. I think the court's going to strike down the New York law with regard to the requirement for a concealed weapons permit. Not sure how the court's going to specify what states can and can't do with regard to concealed weapons. But I think we're going to see a major expansion of gun rights from the United States Supreme Court. And again, we'll see it between now and the end of June. A third area that's on the docket this term concerns the separation of church and state. And the major case about this is a case called Carson versus Macon. Since the 1940s until very recently, the issue with regard to aid to religious schools was, when does a particular form of government assistance, when given to a religious school, constitute an establishment of religion? So to be clear, there were cases before the Supreme Court about if the state provides, or the school district provides, audio-visual equipment for children in a parochial school, is that an establishment of religion? If the government provides sign language interpreters for hearing impaired students in parochial schools, is that an impermissible establishment of religion? If the government provides, say, buses for field trips to children in religious schools, is that an impermissible establishment of religion? The question was, when may the government provide such aid without it being a violation of the Establishment Clause? Now the issue is very different. Now the issue is, when must the government provide aid to religious schools, or it's a denial of free exercise of religion? The initial case about this was not quite 4 years ago, Trinity Lutheran versus Comer. The state of Missouri gave aid to schools for surfacing playgrounds. It was to put a softer material on playgrounds so that if children fell, they're less likely to be injured. The state of Missouri would provide the aid for this material to public schools and secular private schools, but it wouldn't provide the aid to religious schools. There's a provision of the Missouri Constitution that prohibits direct or indirect government aid to religion. Missouri used this provision to say it couldn't provide assistance to parochial schools. The Supreme Court declared this unconstitutional. Chief Justice Roberts wrote the opinion for the court. Justice Sotomayor wrote the dissent. Chief Justice Roberts said, whenever the government provides aid to secular private schools, it must provide that aid to religious schools, unless doing so would violate the Establishment Clause. And virtually nothing violates the Establishment Clause for the conservative justices. Now, Chief Justice Roberts, in a footnote, then said, this is just a case about aid to playgrounds, not about anything else. Well, 3 years later, I should point out, Justice Sotomayor in her dissent in Trinity Lutheran said, this is the first time in all of American history that the Supreme Court has said that the Constitution requires that the government give aid to religious institutions. 3 years later, the court decided Espinoza versus Montana Department of Revenue. Montana adopted a law that said that people who gave money to a private school tuition organization could get a tax credit up to $150. Almost all of the private schools in Montana are religiously affiliated. The Montana Supreme Court found that this violated the Montana state constitution. Montana, like Missouri, has a provision that the government can't give direct or indirect aid to religion. The United States Supreme Court reversed 5-4. Now, I would have thought with the state Supreme Court saying a state law violates the state constitution, the Supreme Court wouldn't get involved. But Chief Justice Roberts, joined by the 4 then conservative justices on the court, said, whenever the government gives aid to private secular schools, it must give that aid to religious schools. This brings me to the case that was argued in the Supreme Court in December, Carson versus Macon. Carson versus Macon involves state of Maine. There are parts of Maine that are too rural to support a public school system. So in those areas, Maine pays for parents to be able to send their children to private school. The parents can send the children to any secular private school, but the aid can't be used in a religious school. Maine says our interest is in providing a secular education for all of the children in the state. Our interest in making sure that taxpayers don't have to pay taxes to support the religions of others. A couple of religious schools, a couple of parents who want to send their children to those religious schools brought a challenge to this and said it violated their free exercise of religion to not allow them to be using the money in religious schools. From the oral argument, it seems clear that the state of Maine is going to lose, that the schools and the parents are going to win, and it's going to be 6-3, split along ideological lines. And I think the Supreme Court is going to broadly say, anytime the government gives a benefit to a private secular organization entity, it must give the benefit to religious entities as well. And this is dramatic change in the law. All of the cases that I've just described have been argued to the Supreme Court. Each will be decided by the end of June of 2022. But on Monday of this week, the Supreme Court granted review in 2 cases that will be argued next October. Both involve affirmative action. In 1978, in Regents of the University of California versus Bakke, the Supreme Court, 5-4, said that colleges and universities have a compelling interest in having a diverse student body. College universities may use race as one factor among many in admissions decisions to benefit minorities and enhance diversity. In 2003, in Grutter versus Bollinger, the Supreme Court reaffirmed the holding from Bakke. Justice Sandra O'Connor wrote for the court, and she said, college universities have a compelling interest in a diverse student body. College universities may use race as one factor in admission decisions to enhance diversity to benefit minorities. In June 2016, once more the Supreme Court said this. The case was Fisher versus University of Texas at Austin. Abigail Fisher applied for the University of Texas and was not admitted. She went to Louisiana State University, from which she graduated. But she sued the University of Texas, saying the failure to admit her denied her equal protection. The Supreme Court ruled in favor of the University of Texas and against Abigail Fisher. The court said the University of Texas has a compelling interest in diversity, and it demonstrated there was no other way to achieve it. 2 of the justices in the majority in that case were Justices Kennedy and Ginsburg. They're no longer on the court. They've been replaced by far more conservative justices, and Justices Kavanaugh and Barrett. 3 justices dissented in that case. Justice Alito wrote and was joined by Chief Justice Roberts and Justice Thomas. All are vehement foes of any form of affirmative action. Well, on Monday, as I said, the Supreme Court granted review in 2 cases. One is Students for Fair Admission versus University of North Carolina. University of North Carolina, a public school, uses race as one factor in admission decisions to benefit minorities. A federal district court upheld this as constitutional under Supreme Court precedent, and the Supreme Court just granted review. The other case is the Students for Fair Admission versus President and Fellows of Harvard College. It involves Harvard for its undergraduate admissions, using race as a factor. Now, the difference between these cases is the law that applies. The North Carolina case involves the Constitution because it's a public school. The Constitution doesn't apply to private schools. So the Harvard case involves Title VI of the 1964 Civil Rights Act that prohibits recipients of federal funds from discriminating based on race. But the Supreme Court has made clear that the legal test is the same, whether it's under equal protection against a public school or against Title VI against a private school. Given the current composition of the court, I think there's little doubt, but the court's going to overrule the earlier cases and say that college universities must be colorblind in admissions. This is going to have a devastating effect on minority admissions and diversity, especially colleges and universities. We saw this happen here in California. After Proposition 209 was adopted in 1996, there was a precipitous decline in minority enrollments, say UCLA and at Berkeley. Proposition 209, remember, was a voter-passed initiative that said that the state of California and its political subdivisions can't discriminate or give preference based on race, gender, and education, contracting, or employment. The effect of 209 here in California was dramatic. So, for example, the admission rates for underrepresented minorities at UCLA went from 52.4% in 1995 to 24% in 1998. As a result, the percentage of underrepresented minorities fell by more than half, from 30.1% as the entering class in 1995 to just 14.3% in 1998. And the effects were not short-lived. In 2012, 16 years after Prop 209 was adopted, the entering class at UCLA was only 12.6% underrepresented minorities. So it went from 52.4% down to 13.6%. As the percentage of Latinx individuals increased in California, there was still a precipitous decrease in the number of Latinx students at UCLA. The effect of eliminating affirmative action is that at elite college universities all over the country, there will be the effects that we saw in California from 209. Now, colleges and universities in California have found ways consistent with 209 to achieve diversity, but it took a couple of decades for them to get there. Also, there's a tremendous will to achieve that. I worry that when the affirmative action cases are overruled by the Supreme Court, it's going to mean a precipitous decline in minority enrollment, and some schools aren't going to do the enormous work that's necessary to overcome it. The reality is that the long history of race discrimination in our society, the continued race discrimination in our society, means that without affirmative action, it's difficult, if not impossible, to achieve racial diversity. Diversity matters. In a brief to the Supreme Court, the president of the University of California and the chancellors said, powerful empirical evidence consistent with the University of California experience shows that when accompanied by meaningful cross-racial interactions, diversity yields substantial educational benefits. As I mentioned, I've been a law professor now for 42 years. I've taught classes like constitutional law and criminal procedure in rooms that were almost all white, in rooms with a significant number of minority students. The latter is a vastly different educational experience for all. When there's Black and brown men in the room, when I teach criminal procedure, who can talk about their experience of being stopped by the police just for driving while Black or driving while brown. There's an effect in education for everyone. When we discuss affirmative action, having a diverse class produces much different discussion. We need to prepare our students for the clients they'll be dealing with, the judges they'll be appearing before, in a very diverse society. We can't do that in a school that's almost all white. So those are four areas where I think we're going to see a dramatic change in the law: abortion, gun rights, separation of church and state, and affirmative action. I don't think it's coincidence that those are areas high on the priority list in terms of the conservative Republican agenda. They now have a majority to implement their agenda on the Supreme Court. So this brings me to the third and final part of my remarks, the future of the Supreme Court. Maybe the easiest way to begin here is to focus on Justice Amy Coney Barrett. She was 48 years old on the day she was sworn in as a justice, October 26, 2020. If she remains on the Supreme Court until she's 87, which was the age Justice Ginsburg died, she will be a justice into the year 2059. California Supreme Court Justice Leandra Kruger has been much mentioned in the last 2 days to replace Justice Breyer. Justice Kruger is 45 years old. If she stays on the court until she's 83, the age at which Justice Breyer would be resigning from the court, Kruger will be a Supreme Court justice then for the next 38 years until the year 2060. I've long thought that the best predictor of a long lifespan is being confirmed for a seat on the United States Supreme Court. When Barrett was sworn in last October, Neil Gorsuch was 53, Brett Kavanaugh 55, John Roberts 65, Samuel Alito 70, Clarence Thomas 72. It's easy to imagine these justices being together for another decade or two. Well, this then brings me to the news of yesterday, Justice Breyer's retirement. Stephen Breyer was nominated for the Supreme Court and confirmed in 1994. He had an impressive career. He graduated from Harvard Law School, clerked on the Supreme Court for then Justice Arthur Goldberg, became a Harvard Law professor, worked as chief counsel to the Senate Judiciary Committee when Ted Kennedy was chair. Breyer became a judge on the United States Court of Appeals for the First Circuit, and then a Supreme Court justice. Overall, Breyer was liberal, but more of a moderate liberal than a liberal in the vein of a Sotomayor or Ginsburg. Breyer was very liberal on abortion. He wrote some of the most important Supreme Court cases in recent years protecting abortion rights. He's very liberal when it comes to affirmative action. Probably his most famous opinion will be a dissent he wrote in 2007, defending the use of race to achieve diversity in schools. Breyer was the most outspoken foe of the death penalty on the Supreme Court. But there were other areas where Breyer didn't join the liberals. There were a number of cases in the last decade or so enhancing the rights of police, and Breyer joined with the conservatives, sometimes Justice Scalia in dissent with the liberals. When it comes to separation of church and state, Breyer was not with the liberals, so not with the conservatives either, except in result. I argued a case in the Supreme Court, it's now over 15 years ago, a case called Van Orden versus Perry. It involves a 6-foot-high, 3-foot-wide 10 Commandments monument that sits directly at the corner of the Texas State Capitol and the Texas Supreme Court. I argued that to put this religious symbol at the seat of Texas state government is an impermissible establishment of religion. I lost 5-4. I got the votes of Justices Stevens, Souter, Ginsburg, and O'Connor, but Justice Breyer joined with the conservatives to uphold that. And I can give other examples where Breyer was the conservatives on those kind of issues. Just a few years ago, there was a case that involved a 45-foot cross that sits at a busy public intersection in Prince George County, Maryland. Justice Breyer was the conservatives in saying that was permissible. Who might be picked? Who should be picked to replace Justice Breyer? There's an article in today's Los Angeles Times, it's the lead editorial, saying it doesn't really matter that much who President Biden picks to replace Justice Breyer, because it's going to still be a 6-3 court. Of course, that's true, but I think it's exactly the wrong way to look at it. I think President Biden should look at it by asking, who will the Democrats want on the Supreme Court in the year 2040 or 2050? And by that point, this seat on the court could be the swing seat that makes it a more progressive rather than a more conservative court. Whoever holds this seat is likely to do so for the next 30 to 40 years. So I think what's most important is that President Biden pick a progressive for this seat on the Supreme Court. It shouldn't be that Republican presidents pick staunch conservative justices, whereas Democratic presidents pick centrists and moderates. There are a number of interesting names being floated. There's Ketanji Brown Jackson, who's a judge on the United States Court of Appeals for the District of Columbia Circuit. There's Leandra Kruger, a justice on the California Supreme Court. They both have traditional credentials. Judge Jackson went to Harvard Law School, had a distinguished career as a public defender, which is unusual, became a district court judge and then a judge on the DC Circuit. Leandra Kruger was the editor-in-chief of the Yale Law Journal, clerked for the DC Circuit, and then for Justice John Paul Stevens. She had a long career in the Solicitor General's office and is now on the California Supreme Court. Another interesting name being mentioned is Judge Michelle Childs, a judge on a federal district court in South Carolina. She went to the University of South Carolina for law school, a different pattern that we've seen recently. She's recently been nominated for the DC Circuit, so it'll be interesting to see whether she might be the pick. Another name being mentioned is Sherlyn Ifill, who's the head of the NAACP Legal Defense Fund. She's a bit older. She's, I think, about 60 years old, whereas Kruger's 45 and Jackson's 51. But it would certainly send a signal of a desire to put a progressive on the Supreme Court. At this moment, my students are very discouraged about the Supreme Court and constitutional law. I have to confess that I am too. I see a court that is very committed to the Republican agenda and wants to change the law as fast as it can. What I have to tell my students is that they need to look at the overall sweep of American history. That if they do so, there's been such tremendous advances in equality and freedom. And there's every reason to believe that that will continue, notwithstanding this court. Certainly when it comes to race, there's terrible racism and racial injustice in this country today. But compared to what it was in 1787 or 1868, or even the year I was born, 1953, when at that time, every Southern state was segregated by law with Jim Crow laws, or sex discrimination. There is still enormous sex discrimination in the society, as everyone knows. But when I think about law schools, in 1970, 5% of women's students, 5% of law students were women. When I started law school in 1975, 25% were women. Today at my law school, University of California at Berkeley, almost 2/3 of the entering students are women. Or think of it in terms of sexual orientation. It's only 7 years ago that the Supreme Court said that gays and lesbians have the right to marry. There's been tremendous advances in freedom over the course of American history. And so what I try to tell my students is that the late Dr. Martin Luther King got it exactly right when he said, the arc of the moral universe is long and it bends towards justice. Ultimately, what I tell my students is we really only have two choices. We give up or we fight harder. And that means only one choice exists. We fight harder and better than we ever have before. So I've talked for about 45 minutes, and I'm glad now to take your questions for about 15 minutes.
Thank you, although it's quite depressing, isn't it? If people have questions, could you go down to the reactions on the bottom of your screen and open it up and and put the little raise hand sign. Okay. Let's see, so we have Glenn Stephen Colon. Would you like to ask your question?
Sure. Good evening. Thank you so much for participating tonight. Complete abolition aside of the court, what do you suggest is the best strategy to get mainstream Democrats to support unpacking, which would be expanding the court as you've previously proposed? Currently, Biden won't even talk about it, which, sorry, go.
Okay.
We are going to have a very conservative court for the next decade or two, at least, unless the size of the Supreme Court's expanded. There's no other way to counter that. Unfortunately, I don't see a path to expanding the size of the Supreme Court because of the Republican filibuster. The size of the Supreme Court is not set by the Constitution. It's set by federal statute. It's varied between 5 and 10 over the course of American history. 9 is a historic accident. Congress, by statute, could change the size of the Supreme Court. But of course, that would take passing the House and the Senate. And there's no way Senate Republicans are going to do that. They'll filibuster. And as we saw last week, there's no will, at least among 2 of the Democratic senators, to change the filibuster, even to get the voting rights legislation through. So I don't see a path to expand the size of the Supreme Court, at least now. Maybe if the court overrules Roe, if the court hands down many other controversial decisions, there will be the will to do that. One thing that may be relevant here, the Supreme Court at this moment has the lowest approval ratings in its history. According to a Gallup poll in the fall, the Supreme Court has an approval rating of 40% and disapproval of 53%. I think overruling Roe will only exacerbate that. 2/3 of the American people believe that Roe should not be overruled. But at this moment, I don't see a path to expanding the size of the Supreme Court.
Thank you. Charles Hottinger.
Yes, thank you very much, Professor. 2 issues, one of which I've heard that Clarence Thomas is a fan of the Lochner decision of 1905, which I guess more or less said that New York couldn't control worker conditions and wasn't able to impose weekly maximum. And then also, second issue, I understand that there's a decision or a desire to, shall we say, undo the regulatory state. Like even with, I understand there was a comment by John Roberts having to do with COVID. Well, why doesn't Congress, pass the COVID restriction law? In other words, agencies like OSHA couldn't on their own enact regulations that they've been able to. All these things have to go through a gerrymandered Congress, I guess. So under your question, your response, first about Clarence Thomas and Lochner, and then secondly about the like Steve Bannon's war on the what he calls the regulatory state.
Sure. As to the former, Lochner versus New York was a 1905 decision. It involved a New York law that set the maximum hours that bakers could work. There's no more than 60 hours a week, no more than 10 hours a day. And the Supreme Court declared it unconstitutional as interfering with the freedom of contract of bakers and bakeries to agree to whatever they wanted in terms of hours. It was one of many cases between the 1890s and 1936 where the Supreme Court struck down progressive state, local, federal laws protecting workers and consumers. I don't foresee the Supreme Court is going to go back there. I think there's lots of ways in which the Supreme Court is going to protect business, but I don't foresee a revival of that particular Lochner doctrine. And there's actually a reason why I don't think Justice Thomas would agree with that, because he rejects the doctrine that it was based on under the Due Process Clause. So I think it's going to be a very conservative court. I think it's going to be a real erosion of rights. I think there's going to be a real protection of business, but I don't think there's going to be a revival of Lochner versus New York. in terms of your second question, yes, I think that the conservative majority on the court is going to look for many ways to decrease the power of administrative agencies. We saw this just 2 weeks ago. The case was National Federation of Business versus Department of Labor, Occupational Safety and Health Administration. And it involved the Occupational Safety and Health Administration mandate that all employers with over 100 workers have those workers vaccinated against COVID. We have to have weekly tests. And the Supreme Court 6-3 said the agency couldn't do this. Could I ask a favor? Could you excuse me for just a moment? I'll be back in just a moment.
Sure, yes,
I'll be back.
okay. I have a question in chat from Stephanie. Is it Tadeo? Did I pronounce your name correctly? Stephanie?
Yes, yes, actually, it's my husband, Chris, and he's here, so yes.
Yeah, would you like to ask that live?
Yeah, I think you should. Yeah, Chris, why don't you go ahead and.
Sure, I can do that if you
Okay,
prefer.
you would go down to reactions and go down and then raise your hand. Can you do that?
Okay,
Great, thank you.
Okay, I mean, instead of my asking it, because there might be follow-up, but yes.
Okay, okay, great, thank you.
Let's see, I think I found some questions people had sent me.
And Brody, I put in a question from Sheila as well.
Yeah, is Sheila here?
I think so. Sheila, are you?
I'm here.
Oh, okay, you don't want to ask it, or would you?
I can ask it.
Okay, I'm good. I'm glad you got on. Okay.
Oh, I've been on the whole time.
Oh, good, yeah. Yeah. Do you know how to go down to reactions and hit raise your hand?
Actions.
Reactions on the bottom of your screen?
You know, I think, I see the arrow, but it's the block is that one.
When you hit reactions, it opens up a little pictures. And one of them says raise hand.
Up there. Where do you raise your hand?
That's under.
Where's the picture? That one?
If not, we can ask it for you, or we can call on you.
I'd like to get back where I can see the faces.
Okay, then, yeah.
Click on this.
If not, we will call on you, but we've got 3 other people with questions.
Nothing is bringing the faces back.
Here,
You go up to view on the right-hand top side.
View. Start my video.
No. Okay. Harry, can you help her?
Oh, he's here. He doesn't see it either.
Oh, okay. In your screen,
View.
go up to the upper right-hand corner. And there's a little word that says view.
Here, it's here in this one. View.
Oh, that way up at the top on the left.
Yeah.
Ooh, I don't know if you're on an iPad or what.
Yeah.
I clicked
On
on
Mac.
it.
And you should be able to say gallery.
actually, Sheila, I think you're trying to get your video working, and on the lower left-hand corner, there, you should have stop video or start video.
I
Okay,
had to
we've got
start my
Dr.
video.
We've
Right.
got Dr. Chemerinsky.
There you go. There you go.
Thank you for letting me excuse myself a moment.
Yes,
It's
thank you.
Professor
Okay, our
Chemerinsky.
next question.
Okay.
I've lost my ability to
Sheila,
see.
can you please mute yourself? Thank you. Our next question is from Nichole Hsu. You have to unmute yourself.
Hi, Professor. Thank you so much for your time. I'm actually a volunteer with Moms and Man Action for Gun Sense in America. And a lot of our strategy over the last several years has been to work because we're not able to get some key legislation passed at the federal level, we've been focusing on state levels. And a few years ago, we were able to kill concealed carry reciprocity laws. We've been focusing on ensuring that that doesn't happen at state levels, and we've been pretty successful with that. If what you're suggesting happens, how does that work with state laws that are in place already against concealed carry reciprocity?
I think that they'll be challenged in courts. A lot is going to depend on how the Supreme Court defines the right to concealed carry. But I think that the Supreme Court is going to find some right to have guns in public and some right to have concealed guns in public. And we'll need to read the opinion, but I think that the kind of laws you're describing will be vulnerable to challenge. I don't know what the courts will ultimately do with them, but I think that.
So if like one state has open carry and concealed carry reciprocity is in place, they can come to California where it's illegal in the state, but do you know what I mean? Like that could
But
happen.
see, I think what the court may do is say that the California law that limits concealed carry violates the Second Amendment and deal with it that way, not through the reciprocity issue.
Okay. Depressing, thank you.
Thank
I'm the
you.
messenger.
Thank you. Next from Chris Tadeo.
Yes, hi, Professor. I was wondering why why under the Texas abortion law why won't those suits be thrown out for lack of standing?
Suits by who? Suits in Texas court against the doctors of people who aid or abet abortions?
Right. Why the plaintiff won't have standing in those cases?
They would not have standing to sue in federal court because they don't have a personally suffered injury. But states can create standing for anyone they want in state court. And Texas is given standing by state law to those plaintiffs in state court. That's what the state statute does. And it's important to recognize Article 3 of the Constitution limits standing in federal court, but states can create standing for anything they want in the state court. And Texas has done that here.
That it seems so arbitrary, though.
But each state gets to decide who it's going to give standing to in state court. And
Wow.
if Texas wants to do that, or any other state, it's entirely up to the state who it wants to allow to have standing in state court. And that's what Texas has done here.
Thank you.
Oh, thank you for clarifying. Stuart Winter.
Yeah, thank you. A couple of proposals I've read about for making the Supreme Court composition better have included term limits and also the possibility of having some limit on how many Supreme Court justices an individual president could approve, maybe one per term or two per term. Do you think, I can understand that these things are very unlikely in the present political climate, but do you think these things would make an improvement in the long term?
I would like to see term limits for Supreme Court justices. I'd like to see 18-year non-renewable terms. So every president would get to appoint 2 justices, and it achieves the goal of both of the suggestions that you made. Some of this is just that thankfully life expectancy is a lot longer now than it was in 1787. In 1787, average life expectancy was 36 years. Clarence Thomas was 43 years old when he was put on the Supreme Court. If he stays on the court until he's 90, the age Justice Stevens retired, he'll be a justice 47 years. If Leandra Kruger is nominated and confirmed, and she lives till she's 90 on the court, she'll be there for 45 years. That's too much power in one person's hands for too long a period of time. Too much depends on the accident history is when vacancies occur. So that's why I like 18-year non-renewable terms. But it's not going to happen, you're right, because I think in order for it to happen would take a constitutional amendment. And I don't see a constituency that cares enough that would do the work to get Congress in the states to adopt it.
Thank you for clarifying that. Ginny and Big Hooper?
My question concerns the next presidential election. I've heard it stated that there's all probability it will end up in the Supreme Court because of the legislation passed with so many states restricting voting rights and allowing states who have Republican election commissioners to throw out the results of an election without any proof. What do you think?
I'm very afraid of the 2024 election for the reasons that you say. I'm afraid in terms of the laws that have been adopted in 19 states last year to restrict voting, all meant to suppress voting, especially by voters of color and Democratic voters. I'm worried about the effort in some states to give political control over the electors of the state so that if it had happened in 2020, some states could have gone for Trump, notwithstanding the popular vote and where the electoral vote should have been.
Right.
I don't know that that means it will end up in the United States Supreme Court. I do think it means we have every reason to worry. And one of the really tragic aspects of the filibuster last week to the voting rights bill is it could have countered some of that. And because of Joe Manchin and Kristin Sinema, it didn't happen.
Yeah. Oh, another depressing answer. Charles Hottinger, I see that your hand is up, but we have Ellen Nelson has emailed me a question. Ellen, you're here. Would you like to ask your question?
No, if you read it, I would appreciate it.
Okay, here's the question. I'm not sure if I understand it. So Ellen, you might have to explain. Question. There are a variety of opinions about the court's ability to rule without extreme bias. And there are a variety of proposals to, quote, fix the court, presumably to mitigate bias. This is not a new perception and has been attributed to many other Supreme Courts. This seems to me to be a most important conversation about the court because it speaks to its institutional validity. What is your view of the opinions and proposals?
I don't know what extreme bias means. The reality is that the ideology of the justices determines the outcome of many cases. It's always been that way. I mentioned the time, the Lochner era from the 1890s, 1936, where a very conservative court struck down over 200 progressive federal, state, and local laws. The Warren Court was very liberal and handed down so many important rulings in a liberal direction. The current court, as a conservative majority, is going to be there. The Constitution is written in very broad language. What's cruel and unusual punishment? What's due process of law? The answers to those depend on who's on the court and their values. Constitutional law is often balancing competing interests. How the balance is struck is who's on the court. So I don't regard that as bias. I regard it as inevitable to a human court interpreting and applying a constitution.
Okay.
So Brody, Sheila
Yes,
Fish
Sheila.
would like to ask a question. Can't raise her. There.
Yes.
Sorry, I couldn't find the hand, neither here nor right. My question is about Clarence Thomas recusing himself from bills that have anything to do with any of the major organizations that his wife is involved in.
There's a major, big article in the New Yorker this week on
Really?
that very topic.
Oh,
On the Supreme Court, it's left to each justice to decide for himself or herself whether to be recused. And so it's up to Clarence Thomas whether to recuse himself. And it's clear he's not doing so. And there's no mechanism to force him to do so.
thank you.
More sad news. Okay, thank you. Charles Hottinger.
Yes, Professor. A two-part question that's related as far as President Biden getting his nominee approved. Now, I understand that the Republicans could block it potentially by boycotting the Senate Judiciary Committee meeting, and it would not go any farther than that. Is that correct?
No, the Democrats can change the rules. There was an agreement that Schumer and McConnell struck about allocating power when the Senate's 50-50. But if the Republicans were to do that, the Democrats, assuming the 50 of them would vote together in Kamala Harris, they can change the rules.
Okay. The second question is, like when Merrick Garland was nominated and McConnell refused to hold hearings. I mean, could Obama have invoked what's that? He who is silent is seen to consent, simply by saying that.
If Obama could have done it, he would have done it. It's clear by tradition, if not the text of the Constitution, that for someone to become a Supreme Court justice takes approval of the Senate. For someone to become a federal judge or an ambassador or a cabinet official takes the approval of the Senate. The only mechanism around that would be a recess appointment, and the Senate wasn't going into recess. They weren't going to give Obama the chance to do that.
So what's that term? Quitacit consentire videtur or something like that? Doesn't cut it.
I don't know the Latin phrase, but no, there was no way. If there were, Obama would have done it.
Yeah. Okay. Thank you.
Okay.
Well, Professor.
I think Harry Fish had one more question.
Oh, okay. We'll get one more question in. Harry?
Thank you. I wanted to know your reaction to the San Jose law that is going to require gun owners to have insurance.
I think it's constitutional. I think it's going to be litigated, and I expect to play some role in defending the law.
Great. Thank you.
Good.
Yay, great.
I've spoken with the mayor of San Jose, and I've spoken to the lawyer who's going to be the lead lawyer defending it, and would be delighted to be part of, in some way, helping to defend the law in the courts.
We're happy to support you. That sounds great.
Oh, good. We have some good news. Professor Chemerinsky, do we have another question from Veronica or not?
Sure, let's make this the last one.
No, she's celebrating your participation in that defense.
Oh, you were celebrating. Okay. Well, then we'd have no more questions.
Okay.
Oh, thank you so much, Dr. Chemerinsky. We have enjoyed it so much.
Thank you for having me.
Really
My pleasure.
And even though there's some terrible news, at least we know and have confirmed our terrible news, but some good news. So thank you for joining us and giving us your time. We appreciate it.
My pleasure. Thank you for having me.
Okay, thank you so much. We're going to continue our meeting. Okay, let me get my notes up. Okay. We have, let's see. I'm sorry if I'm taking too long here. I think we're going to hear from our local and state legislation. And part of that is our first speaker is R.L. Miller. R.L., are you here?
Yes, I am.
Oh, good. Okay. Because I'm sure you probably, excuse me, you probably heard about rooftop solar, but maybe we don't know the whole story. So please, R.L. R.L. is I know her from being the lead of the Environmental Caucus. Whenever I went to the state convention, I'd go to the Environmental Caucus and there'd be 200 people of us packed into the room to listen to R.L. She's really renowned speaker, and we're so happy that you're here. Thank you so much.
Thank you so much. I've got 5 minutes, 3 minutes. I'll try to keep it short because you guys have a very
you have 5 minutes. Yes.
Yeah, and I cannot possibly follow Professor Chemerinsky. He's great. Okay, so my name is R.L. Miller. I was the chair of the Environmental Caucus until this past April. I'm now an elected member of the DNC. And in my spare time, I run an outside group by the name of Climate Hawks Vote. We've been working closely with Solar Rights Alliance on the issue of rooftop solar. And people just sort of drop a smiley face or something like that if you either have rooftop solar already or if you intend to get it. You know, just put a little happy face or whatever it is, or clap or raise your, you know, raise your thumbs if you're for rooftop solar. I'll tell you right now that in going around the state and talking to as many people as I can, I've been finding that just about everybody either has rooftop solar or wants to get it, or is simply in a position where they can't get it, such as they live in an apartment or a mobile home. But almost nobody just doesn't even want rooftop solar, doesn't want to have anything to do with it. So solar polls like mom and apple pie, which is something that I hope the PUC will keep in mind. A few years ago, I took money out of my retirement account to go pay for rooftop solar. I'd been meaning to do it for a while. It was on my list of things to do. It was expensive, but I was also tired of being hit with $200 a month electricity bills. And the solar tax credit was starting to fade beginning end of 2019. And so I figured that's the sign for me to do it. I'll take money out of my retirement accounts. I'll pay for rooftop solar. I'll own my system. And if you've ever gone through something similar, you know that the solar salespeople have all sorts of charts showing you that, you know, if your electricity bill is X and it goes down to $7 a month, then the system will pay for itself in Y years, and also known as the payback period. So 3 years, 5 years, mine is going to pay for itself in 7 or 8 years. Which is all very well and good, and I relied on that, and I was very happy with the system. Now I feel much better about charging my Tesla. Fast forward to last December, last month, PUC puts out a decision that would basically gut rooftop solar in California. And this applies more to the people who have not gotten solar on their roofs, but are going to, than it does to me, because I'm going to be grandfathered in for a few years. But I'm fighting for you as much as I'm fighting for myself, because I believe that rooftop solar is one of the many solutions we need to climate change, which, in case you haven't noticed, is tearing up California. The way this works is right now I pay for something called a transmission fee and a generation fee. And in return, I sell my excess solar back to the grid, back to, in my case, it's SoCal Edison. I'm down in Ventura County. I sell it at a rate of 25 cents per kilowatt hour. And the utility, I don't actually get any money from this. This is just the credit that makes my bill manageable. Yes, say hi to dogs who are wandering in. But not dogs talking, please. Sorry. The decision that they've come up with that is so far a proposed decision, and it was supposed to be final today, but put a pin in that, I've got something more on that, would not only reduce drastically the amount of credit I would get, it would cut it down from 25 cents to 5 cents, but it would also stick me with a fee for, they can't really explain what, they call it like maintenance of the grid. And this fee would be an average of $57 a month for every solar homeowner in California. My system is a little larger, so I think I'd be paying about $80 a month. And suddenly the system is no longer affordable. To be specific, this would make California the third most expensive state in the country for rooftop solar. It would be behind only Wyoming and Alabama, but it would be more expensive than West Virginia or Mississippi. And as a native Californian, I don't really appreciate my state being compared badly to West Virginia. So PG&E, this whole plan, this whole decision that they've handed down is PG&E's dream. It's what PG&E has been working for many years. And it would also gut the industry. Basically, nobody would go for rooftop solar. Instead of the system paying for itself in 5 years, in PG&E territory, it might pay for itself after 20 years. In SoCal Edison and SDG&E where I live, it would never pay for itself. And so the only people who'd be going rooftop solar would be the billionaires. This is not a good situation. All those clean energy jobs in the solar industry were just bye-bye. So at a time when we're trying to move move oil workers out of the oil industry and into clean energy jobs, all these clean energy jobs would go bye-bye. Decision was supposed to be final today. PUC held a hearing. They're not going to put out their final decision until February because I don't think they understood the blowback that they were going to get. Schwarzenegger has spoken out against it. Dianne Feinstein has spoken out against it. Editorial boards of Los Angeles Times, Sacramento Bee, and San Francisco Chronicle have all been up in arms about it. We've done rallies, we've done protests, we've done petition deliveries. I'm gonna drop, I guess I can't drop a link in the chat, but I've been using the Climate Ox Vote list to get people to either send letters to the governor's office or call the governor's office. And between one thing and the other, Gavin Newsom heard us. And at a press conference last week, he said, we're going to be taking a look at that decision. And so we think he's going to do something about it. We think he's going to be the guy to fix this. We hope he's going to be the guy to fix this because this would be an unmitigated disaster. And for those who pay attention to national politics, which I hope is all of us, he's also giving right-wing Republican governors a playbook to strangle rooftop solar. Right now, Florida is considering net energy metering, and he's going to be giving Ron DeSantis a playbook to make rooftop solar unaffordable in the Sunshine State. He doesn't want to be known as the governor who instituted a backbreaking solar tax. He wants to be known as the solar hero. As I said before, solar polls like mom and apple pie. So my plea to you is to send a letter, get involved. If you already have rooftop solar, join the Solar Rights Alliance, which I've been working with them very closely, and they're the group that speaks out for solar homeowners in California. You get the idea. Have I run out of time yet? I hope I'm good.
I've just found the link and I'm of your website. Is it climatehawksvote.org?
Yeah, climatehawksvote.com. And specifically, we're asking people to send a letter. And I'll just send the link over to you and you can decide whether to put it in the chat or distribute it out to people or whatever. Okay.
Just a sad thing. Do you think the CPUC will have anything, will decide against this, or and what will they'll drop it and they won't have this fee?
No, I think, as I said before, they were supposed to make this final today. They heard 5 hours of testimony, of which 4 people spoke out for their proposed decision, and the rest of us were all up in arms. I think that they're going to nibble around the edges. I think that they're going to put out a decision in February that's going to be, it's going to maybe knock the fee down from $57 a month all the way down to $54 a month. But it's really going to then, the decision then goes over to Governor Newsom, and he can be the transformational agent of change that I think he can be. And so I really want to emphasize to people, by the way, if you are calling the governor's office, please do so nicely. This is a case where we want to give carrots to our Democratic leaders, not throw sticks at them. I think he's going to do the right thing. I think he knows that this is a big problem, and the blowback has been phenomenal. New York Times has written about this. Sammy Roth at the Los Angeles Times has been on this. It's just been a nightmare of a story from the point of view of the PUC. So I think we can turn this around.
Chuck, do you have a quick, Hunter, do you have a quick question?
Yeah, quick question. Yeah, I saw the New York Times article from 3 days ago that said that the labor unions were supporting this rule change also. Is that correct?
Yes, it is. And specifically, it's being supported by the IBEW. And IBEW has signed a contract with PG&E where they agree to work together on areas of competition to their model. The business model that IBEW and PG&E prefer is the big solar farms out in the desert. And to be clear, we need both. We can't do this on rooftop solar alone. We have to use desert solar too. Most of the solar companies are mom and pop. They're not unionized. And frankly, when I go around and speak to renewable energy industry, I tell them to please consider being less hostile to unions. Not so much the mom and pop, the 5-person shops, but if you're big enough to be publicly traded, Tesla, you're big enough to be unionized. And they're creating themselves a lot of trouble. And so, yeah, there's a bit of a war going on here between IBEW and the non-unionized rooftop solar installers. And that's part of what's going on here.
Oh, that's complicated. Yeah, that's too bad about IBEW.
Yeah.
Thank you so much, RL. We're going to move on. So we have we have a lot of speakers here. We now have Mark Landuyt. Rick, would you like to introduce him?
Sure, it'd be my pleasure to reintroduce a friend of the club, Mark Van Landuyt. Mark is the director of our Revolution East Bay. He's also co-founder of the Bay Area Green New Deal Alliance and chair of the Mount Diablo Sierra Club. Mark is going to talk about Assembly Bill 1400, which is guaranteed health care, and tell us what we can all do to help its passage. Mark, you've got the floor.
Thank you, Richard. Thank you, Brody. Good evening, San Ramon Valley Democrats, the only Democrats that matter. Thank you for being civically engaged, and thank you for helping bend the moral arc of the universe towards justice, in the words of Martin Luther King Jr. AB 1400 is CalCare. CalCare is the single-payer universal healthcare bill being put forth by Assemblymember Ash Cholera of San Jose. It's currently making its way through the California Assembly. And it's timely that California is talking about healthcare now, because what we learned from this pandemic is that our neighbor's health is our health. What is in CalCare? CalCare extends care to include dental, vision, and hearing, full pharmaceutical access, and also long-term care. I should note that AB 1400 is an assembly bill. There's also the funding amendment called ACA 11. And these two bills have two different journeys ahead of them. So AB 1400 has cleared all its committee hurdles in the Assembly. The Healthcare Committee, the Appropriations Committee, all passed. What they both have in common is that both AB 1400 and ACA 11 are going to be fought tooth and nail by the insurance profiteers. They're going to pour millions and millions of dollars into fighting CalCare. What we need to know, and what we need to let our neighbors know, is that CalCare, a single-payer healthcare system, will be far less expensive than our current healthcare system. CalCare is estimated to save tens of billions of dollars to Californians. And it should be noted that the state subsidizing of healthcare in California is already in the tens of billions of dollars. Michael Leidy adroitly said that we are already paying for a single-payer system, we just aren't getting one. And when people don't have to pay premiums, co-pays, or deductibles, CalCare functions as like a tax cut. It puts more money in regular people's pockets. And what we need to reinforce for our friends and neighbors is that when we pay for healthcare through taxes, It's like paying $10 and getting $50 back, if you get the analogy. And also, thanks to the stipulations of the ACA, Obamacare, California can get waivers from the federal government to have the funds that usually go into Medicare and Medicaid and be placed into a state healthcare program. We can only do this with a Democratic administration in the White House. There's no hope of doing it with Republicans in power. CalCare, AB 1400, is going to be voted on Monday, January 31st, in the full assembly. Our task for tonight is to please call our assembly person, our friend Rebecca Bauer-Keon. Ask gently, delicately, firmly, and beautifully, ask them to vote yes on AB 1400. Do it tonight. Do it tonight, unless the machines are filled or you really need to talk to someone. And according to Sacramento, AB 1400 has gotten the most engagement to assembly members. And it's not surprising. California needs CalCare. We need universal health care. Single payer universal health care is what Democrats have been fighting for since John F. Kennedy. And now it is time to get it done. And it appears that California has to do what it has to do. And what California does best is lead the nation. So it's our time to lead the nation. Please, please give a phone call. I will put some information in the chat, but make it simple, make it to the point. Please ask for our assembly person to support AB 1400, the Healthcare for All Guaranteed Healthcare Act, CalCare. Thank you very much. And I know you have a long meeting ahead of you, so don't forget, make that phone call. Monday is the final day. Thank you, San Ramon Valley Democrats.
Thank you, Mark. I don't see any questions, so we're going to move on. Shirley Shelangoski, are you here to talk about the Disclose Act on the ballots?
Yes, the Ballot Disclose Act. I want to mention real briefly also, we've had some success with the open source paper balloting out of San Francisco. There was a pilot project for San Francisco and LA, but the city council in San Francisco just voted Tuesday 11-0 on a pilot program that they will use the open source balloting, paper balloting next November. So that was a victory. And then our main bill at the state level is AB 1416, the Ballot Disclose Act, sponsored by Kevin Mullen and Evan Lowe. And I want to thank San Ramon Valley and many of the other Democratic clubs that are here for endorsing it last year. It was made a 2-year bill, and it's now starting through the started through the assembly. It passed the assembly election on 1/12. It passed assembly appropriations on 1/19, and it's also going for a full assembly vote on the 31st, next Monday. So it has, and then it'll go to the Senate by June. So my ask of you is to call your assembly member to please tell them to vote for it. I think Rebecca Bauer-Kehan probably, we probably have her vote. I know she voted yes on the amendments today. But with this, for anybody who maybe isn't familiar with it, I mean, I know the club has endorsed it, but I guess I should explain a little bit what it is. The Ballot Disclose Act is going to put a list of supporters and opponents directly on the ballot from the voter pamphlet guide. I think that would make a lot of difference as far as transparency. You know, if we knew that Sierra Club was supporting something, or, you know, our friendly people, you know, we're thinking, okay, maybe we didn't have time to do all our homework. I mean, there's a lot of people that don't even look at those pamphlets, but we're taking the names from there and place them directly on the ballot. So it's going to be a lot more transparency. And I think because we spend so much money on the state initiatives, it's going to be a really good thing. So if you could call your assembly member to please vote for it. And another ask is to go to our website, and it's www.yesfairelections.org, and sign our petition for Assembly Bill 1416. And if anybody is really interested in it, we do need phone bankers. I've been phone banking all week. What we do is we call the constituents to call their assembly members. And there's key targets that we always aim for. And also, if you're a Twitter person, you can go on Twitter and like and retweet retweet our tweets.
Good.
So,
Thank you. I think we have a quick question from Eloise.
okay.
Eloise, do you have a quick question?
Shirley, give us that website one more time.
www.yesfairelections.org. I can put it in the chat as well.
Yeah.
Oh, there we go.
Okay, now we have Eloise. Okay.
Okay, I'm backing up a little bit. I just wanted to point out that IBEW is the union for PG&E, and they have been their mouthpiece forever. They've opposed, community choice, et cetera, et cetera. So I don't think they're a fair representative of the union opinion.
Shirley, do you agree? Okay, Rick, do you want to introduce the next speaker?
Yeah, I would be happy to. Speakers are coming fast and furious here. The next speaker is Gail Murray, and Gail is representing the League of Women's Voters of Diablo Valley. And Gail will describe the upcoming webinar on how the proceeds of the 2020 Measure X tax measure are being used in the gaps that remain. Go ahead, Gail.
Hi, thank you for letting me give this little promotion. The League is having a meeting by Zoom on Thursday, February 17th at 4 p.m. And it's to discuss what's happened with Measure X. Now, you may not remember, as I didn't, what's Measure X? So I looked it up today, and it's a measure that we voted on in 2020 in November to keep Contra Costa's regional hospital open and staffed, to fund community health centers, provide timely fire and emergency response, support crucial safety net services, invest in early childhood services, protect vulnerable populations. And we're all paying a 0.5-cent sales tax to do that. And we agreed to do that, and it won by a majority, 54.45%. And it will raise $81 million annually for 20 years. So this meeting on February 17th is to discuss, is it really doing that? There's been a group that's looking at how Measure X should be allocated. So it will talk about what are the allocations that are coming out of Measure X for this year, and are there still any gaps? There's going to be a panel. The panel will be Chanel Scales Preston, who's the vice mayor. The Pittsburgh City Council will be the moderator, and the panelists are Mariana Moore, who's chair of the Measure X Citizens Advisory Board, Dan Geiger from Budget Justice Coalition, and Supervisor Karen Mitchoff from the Board of Supervisors. So we wanted to let you know, if you want to know how your tax dollars are being allocated, come on February 17th to this league meeting on Zoom.
That's wonderful. Cecilia, do we have the link for that we can post?
Yes, I have put it in, but let me drop it in again just so it's at the bottom of everyone's.
Yeah.
There you go.
Thank you.
Okay, great.
Thank you very much.
Oh, good. Okay, thank you. Next, we also have some important elections for our Contra Costa County positions of county auditor, county assessor, and county clerk. And tonight we have 3 candidates for county clerk. They're here just tonight to give you a 2-minute introduction. Next month, we hope to have a forum, a longer format, where they can tell you more about themselves and we can ask them questions. But tonight is just an introduction. First, and thank you, candidates, for being here. First, we have Devin Murphy. Devin, are you here? I think he was here. I don't know if he's having a hard.
I think he has dropped off.
Okay. Next we have Vicki Gordon, and I see that she's still here.
Good evening, everyone. Yes, thank you for having me. That was a great presentation, very informative. I really enjoyed it. Since I only have a few minutes, let me introduce myself. I am Vicki Gordon, and I am running because of the passion that I've always had to serve. And it's increased and was turned into a blaze by serving on the West Contra Costa Unified School District's Independent Redistricting Commission, and by having a group of well-respected community members led by Steve Weir to ask me to consider running. So when I dug down into the job, and it's a big job, it was a perfect fit for me. Both sides of the office have very different issues and very different needs. And I'll work hard to do both jobs to my very best. A little bit about me. I graduated with a BS in Business Administration, emphasis in human resources and marketing. But when I did graduate, what I really wanted to do was to help and serve. So I went back and got my teaching credential, and I taught at Parkside Elementary in Pittsburgh. And then I moved on to Martinez Junior High School in Martinez. So yes, I taught middle school. I took some time off to take care of my family. We had a newborn and a 2-year-old when my in-laws became very ill. And then when I wanted to go back to the classroom, a group of community members asked me to run for Martinez Unified School Board, where I served for 15 years. But that also gave me the opportunity to volunteer for many organizations. I helped to raise hundreds of thousands of dollars for education foundations, sports clubs, PTAs, boosters, libraries, all for technology and great programs, as well as for other nonprofits. And I also served as officers and ran many of these organizations. When an open seat on the Contra Costa Community College Board became open, I decided to run so that my experience and knowledge could help serve 50,000 students and even our whole community. So I used my K-12 knowledge to restart what is now called Triple CSBA. We mentor and help out school districts and trustees, and I help to build better relationships between community colleges here in Contra Costa and the K-12. I helped to start the College Now program and other programs to help our students be more successful. I worked hard at the community college at the state level on task force helping students up and down the state of California. And I'm still on the community college state task force for Committee for the Diversity, Equity, and Inclusion. They were doing such important work and got very involved, and they asked me to stay on, and I was just honored to be there, and still am going on strong on that task force. And then a year ago, this past December, not this one, but a year ago from this past December, I applied and was appointed by a federal judge to serve on the West Contra Costa Unified School District Independent Redistricting Commission, where my fellow commissioners selected me as the chair. I have experience, knowledge, and passion to tackle the issues facing our county's elections and the clerk recorder office. I have over 23 years on elected boards and financial and fiscal background, running districts with $30 million and $280 million budgets. I understand the issues facing our democracy, our elections, the election process, as well as the issues facing our clerk recorder and our workforce in the office. So that's a little bit about me, and thank you for your time this evening.
Well, thank you, and we look forward to seeing you next month too.
Thank you.
Next, we have Kristin Connelly. Let's see if she's able to unmute herself. I think I saw her here.
Actually, Kristin, you should be unmuted.
Hear me now? You can hear me, Gail?
Yes.
You nod, Gail. Okay. Okay, good. I thought my handy headphones were working, but anyway, my name is Kristin Connelly. Good evening. Thank you for having me. And I have to say, being with Dean Chemerinsky was like taking me back to Fordham Law School. I don't know if you saw me taking copious notes, but that was just terrific that you got him, and he is so accessible. We exchanged emails actually after his presentation. I was just so taken. So I am a former lawyer, but I'm a proud native of Contra Costa. I have deep roots here, like Vicki does. It's great to have someone else who's in this race who cares deeply about elections. So But I grew up in Martinez, a proud graduate of College Park High School in Pleasant Hill. And that definitely set me on my path to have a very successful life. But my passion for elections and expanding the right and access to vote goes back more than 30 years, which is when I first testified on a bill in the state. My first bill that I testified on in the state legislature was about creating a mock election for students in California at public schools. And the bill died on partisan lines. The Democrats voted in favor, the Republicans voted against, and there weren't enough votes to keep it going at the time. And that was my first and early lesson about how Republicans viewed more people voting as a threat and Democrats wanted to increase that access. And I thought that's so dangerous for our democracy. So I am also committed to service. I currently serve as the president of the governing board of the Acalanes Union High School District Governing Board. It's been an honor to serve on this highly functional district board that really cares deeply about equity issues and so many important things, but it has been tough to be a school board member in the pandemic. And I'm grateful to my colleagues and to district staff for the hard work that we've done, but it's helped me grow my skin because I think to be the next clerk recorder, you need to have very thick skin because there are so many threats. So a little bit about my background. After graduating from College Park, I did leave the area to pursue higher education. First at UCLA, where I got a bachelor's in political science, then on to Georgetown for a master's in public policy and to law school. I went to Fordham Law School in the wake of the Bush v. Gore decision. And so that had a huge impact on what I studied and what I focused on. I was the head of the public interest program, did a lot of focus on the Help America Vote Act, which was enacted at the time, and really did what I could to educate students about the importance of poll monitoring. And I, in the spirit of activism, filled up a busload of 2 busloads of students to do nonpartisan poll monitoring in Cleveland, Ohio in the 2004 election. So I do look forward to the opportunity next month to get into more detail, but I'll just leave you with sort of 5 of my priorities for this office would be the battling voter misinformation, expanding access to voting and voter communication on voting, maintaining the integrity of the voting process and an accurate vote count. 4th would be maintaining the integrity of important documents and the vital records that this office handles. And 5th, the continuity of service in the event of a natural disaster is vitally important. We need to think about what's the impact on an election of a PSPS, to the point about, we're talking about PG&E earlier. So my current day job is I'm the president and CEO of the East Bay Leadership Council, where I work with a really broad, big tent, inclusive employer advocacy group. And our mission is to improve economic vitality and quality of life. That experience, plus my many years of service in the nonpartisan advocacy space, including on governance reform, prepares me well for the challenges ahead. So I look forward to getting more of a chance to present and would ask for your vote. You can learn more at kristinconnelly.org.
Thank you very much. Rick, would you like to introduce?
Yeah, it would be my pleasure to introduce another friend of the club and fellow Democrat, Shawn Kumagai. And I've gotten to know Shawn pretty well the last couple of years. Shawn is currently, as you may know from speaking to Rebecca Bauer-Cahan, he's actually on staff as a district director. He is also vice mayor of Dublin after took on that responsibility after he ran and was successful in the city council race. And he's also an Assembly District 16 delegate to the Democratic Party. So he's very busy and he does his jobs well. So I have a pleasure of introducing Shawn Kumagai, who is running for Assembly District 20, the new district.
Yay.
Thank you, Rick, and thank you, San Ramon Valley Democrats. It's really great to be here with you tonight. And, thank you for sticking it out all the way to the end for the candidate presentations. That was a really sobering and great presentation earlier. And what I want to tell you guys about, because many of you know me, that I'm a council member in Dublin, but you may not know so much about my backstory. So I wanted to tell you a little bit about myself. In addition to being a council member and a district director for Assembly Member Rebecca Bauer-Cahan, I'm also a third-generation veteran. I'm son of a first-generation Japanese immigrant, and I'm very proud to be the first openly LGBTQ elected official to serve in the entire Tri-Valley region. I'm also a trained instructional designer and a workforce development professional, and I've served for over 2 decades as an intelligence professional in the United States Navy. Many of you have heard about my path to elected office, but you may not know about my personal backstory. When my parents got divorced when I was 11 years old, my mom loaded us up into a U-Haul and we left the Bay Area to move back to Phoenix, Arizona, where my mom grew up. That's where her parents were. And my grandfather, who's an Army veteran, had retired from the Arizona state government at the time. And he would come over every morning to cook me and my brother breakfast, pack our lunch, and drop us off at school. And through my grandparents' help, my mom went back to school and she started her own career, all while being a single mom. And with a little bit of help from government-backed student loans, from food stamps and welfare payments, and with a whole lot of grit, my late mother got an education and started a career as a registered nurse. She went on to join the Army Nurse Corps, and she retired as a VA psych nurse. What my family's story instills in me is the value of service. Service to country, community, to your family, and to the people that sometimes need an extra boost. Our experience taught me the value of good governance. The government can and should be there to protect our most vulnerable and be a safety net for when people fall on tough times. That's what informs my politics, and that's why I'm a lifelong Democrat. That's why I served in the Navy and continue to serve as a Navy reservist. That's why when a seat opened up in Dublin City Council in 2018, I decided to run, and with this club's help, I won. In my time on council, we've been able to create over 1,000 middle-income housing units in Dublin, and we initiated 3 different affordable housing projects. We set a bold climate action plan that puts us ahead of our emission reduction goals. We took on big tobacco and banned all flavored tobacco products, including vape. We put in place one of the most progressive, safe gun storage ordinances in the state, and we recognized LGBTQ community members in Dublin and throughout the region by proclaiming LGBTQ Pride Month and raising the Pride flag. And we've done so much more. Now I'm running for assembly because I believe this is a serious commitment. And what my work alongside Assembly Member Bauer-Cahan has taught me is that every day you have to serve 500,000 constituents on a variety of complex and nuanced issues. There in the office, we balance their needs and set policy that not only affects them, but every one of our 40 million residents in the Golden State. It's a very serious responsibility, and I decided I'm the person who is best equipped to do the most good for the most people of this district, because I come ready loaded to get to work for the people of this district on day one. And I'll bring decades of experience working within the federal, state, and local government to get results for the East Bay. So San Ramon Valley Democrats, I'm ready to take on the many tough challenges that we're facing here in the East Bay and across this great state. And I hope to be your partner in advancing a legislative agenda that works for the people of the East Bay and our mutual democratic values. I'm happy to answer any questions. I know that the night is getting long. So, thank you very much, Cecilia, for putting all my information in the chat. I have enjoyed the support of many of the members of this club as I've worked as a council member, and I would love to have your support in this campaign. You can go to ShawnKumagai.com to learn more, to sign up to help, or to donate. And please visit me and follow me on Facebook, or give me a call or text me, and I'm happy to chat some more.
Thank you, Shawn. That sounds great. I just noticed that we have our third candidate for county clerk has arrived. So Devin Murphy, are you still here? I saw you come in.
I am. Hi, Brody, Madam President. How are you?
Okay.
Good to see you.
Yes. So yes, you have 2 or 3 minutes.
Absolutely. Well, thank you so much for giving me the opportunity to speak to you all, San Ramon Valley Democrats. I am so excited. I've seen many of you. I see Richard, I see Ellis, I see so many good faces. First of all, my name is Devin T. Murphy. I am the mayor pro tem of a small city of Pinole on the west side of our county. And I am so excited to let you all be some of the first to know that I will be running for clerk recorder of Contra Costa County. I am looking forward to serving this role for many reasons. But for those of you who don't know, a lot of my work to this point has been around voter registration and outreach. I've done incredible work with so many different grassroots organizations, both here in Contra Costa County and the state of California and across this nation, to register voters, young voters, people of color, people from disabled communities, seniors, and making sure that they have not only a voice, but are able to navigate local government. And so I'm coming here today, and I know I'll have another opportunity because I think you all are planning a forum, which I'm really excited about. But I'm coming here today to really ask for your support in this movement that we have around both voting rights, but also around making sure that people who look like all of us on this call have access to navigating their local government. And we can do that through the clerk recorder's office. The clerk recorder does a couple of things. Number one, it's the chief election officer for the county. Number two, it's focused on small business registration and CEQA filing. So if you're an environmentalist like me, you'll probably hear about the clerk recorder's office. And lastly, what I think is so fun about the role, it certifies weddings. We have a huge opportunity to reimagine the clerk recorder's office because guess what? Not only is this one of the first times it's going to be contested in a race, so we'll have noticeability around it, but it's one of the first time we've actually had in a long time conversation about the role of the county clerk beyond just, again, oftentimes people think it may just be the clerk for the note taker for the board of supervisors. Our clerk recorder has an amazing opportunity to really catalyze change in our communities, especially here in Contra Costa County. And that's not just going to be change in our county, that's going to be change across the state of California. I'm looking forward to connecting with each and every one of you beyond just this call. I've connected with many of you before, but I'm looking forward to connecting with more of you to talk about my race. I know I only have 2 or 3 minutes, so Madam President, I'm going to yield my time, but before I go, I just want to say, this is a moment in history that really matters. We all know how we felt on January 6th. We all know how we felt on January 6th, when insurrectionists tried to take over our nation's capital. When January 6th happened, I was not only hurt, I was angry. And I turned that anger into passion by coming back to my city and passing the first resolution in Contra Costa County to condemn Donald J. Trump and also the Capitol 6 insurrectionists. That was a huge moment for me because I said to myself and to my council and to my community that if it could happen in the nation's capital, it could happen in our own communities. And we can't let that happen. We must fight back. This campaign is going to be about fighting back and to make sure that everyone in Contra Costa County has a place in the clerk recorder's office. I'm looking forward to talking to you all more. I'm available on social media. All of my handles right now are at Murphy for Pinole. Let's stay in communication. Let's talk and let's build this movement together. Thank you so much, San Ramon Valley Democrats. I look forward to chatting more.
Thank you, Devin, and we look forward to having you come next month. Even though we had some of our wonderful organizations talk to us before the meetings, we have a different audience now. So I wanted to give some of a few minutes to Moms Demand Action. I was at a meeting last night for Moms Demand Action, and it was in the Zoom, more than 200 participants. It was a wonderful meeting. Nichole Hsu, thank you for coming tonight. Would you like to talk again?
Sure. Thank you, everyone. It's so good to see you all. My name is Nichole Hsu. I'm the co-lead for the Greater Mount Diablo region of Moms Demand Action for Gun Sense in America. And for those that don't know who we are the largest grassroots organization fighting for common gun sense legislation. And we're also fighting to elect gun sense candidates like Shawn and Rebecca Bauer-Cahan. And we also work defensively to stop bad bills. Fortunately, California is a leader in gun violence reduction and common sense legislation. So it's a different beast that we deal with here in California, and we try to continue to lead with innovative laws and ordinances like what San Jose passed the other night. We did have an action, but it looks like it passed unanimously today, which is California has a state law requiring gun owners to secure their firearms if they have kids in the home, separate the ammo from the firearm and lock them up. And many parents and people don't realize that that law exists. And with the increase in gun sales in general and rise in gun violence and suicide and school shootings and mass shootings, it's imperative that we make sure that people know responsible gun ownership. And so the bill that passed out today would require school districts to send communication to parents about this law. So we do all sorts of things like that to try to just spread the word that with gun ownership comes great responsibility, and fight for legislation at the federal level, state level, and local levels. And Brody, I'm so glad to hear that you were on that last night. I was at my kid's soccer game and missed it, so I'm hoping to watch the recording. But we have an advocacy day that will be coming up that we can share through your newsletter for those who are interested in joining and participating. We'll be working on trying to pass a fair amount of bills. And in recent years, we've been working on passing funding for gun violence prevention groups who do the hard work at street level to prevent gun violence from occurring in the first place. So
you mentioned that bill, it passed the assembly. Does it go on now to the state Senate?
It will, and so we'll probably have outreach efforts around that next, but haven't gotten the link for that yet.
Let us know. Thank you so much for being here again.
Thank you all so much.
Rick, would you like to introduce Veronica Benjamin?
Yeah, I'd be happy. Some of you saw Veronica earlier in the meeting before the official meeting started, but we have Veronica Benjamin, and Veronica started the group Conscious Contra Costa after an incident that where a Danville police officer violated Tyrell Wilson's civil rights by shooting him and killing him. This happened, as you may know, in Danville on Sycamore Valley Road near 680 near the freeway. The police officer has been tried by a jury. And Veronica, please tell us more about that case and what's going on now.
Thank you once again for having me tonight. Sorry I was off camera. I'm looking very tired. I had to preserve my face. So the trial was, it was actually quite monumental for Contra Costa County. This was the first time that an on-duty officer had been tried for any kind of act of severe violence against a member of the public. So it was, it's a partial victory. He was found guilty of felony assault with a firearm with enhancements, which is subject to a maximum 17-year prison sentence. That trial wrapped up in October. I'm forgetting the date, but late in October. There was a preliminary sentencing set for January 17th, but that got shifted. And of course, the defense is trying to launch an appeal. And now the new sentencing date is March 4th. That's going to be a Friday. There was a hung jury on the more serious charge of manslaughter. So that's kind of where we couldn't feel fully like justice was brought for Lauderburn and his family. But we all are looking for support regarding the sentencing. Within the entire Bay Area, this will be the first time that an officer has been sentenced since the killer of Oscar Grant about 11 years ago. So it's a huge occasion. It shows the progressive streak of Contra Costa County. It should be a matter of pride, I think, for many of us that we have a DA that was willing to at least bring charges, even though we hope that she will continue along a progressive agenda and bring additional charges against the same officer, Andrew Hall, for killing Tyrell Wilson. That case has yet to, it's a black box. We have no idea where the sheriff's investigation is with that. It was announced to by the Danville Town Council several months ago that the coroner's inquest would be released in early January. Now we're at the end of January. I've been checking the sheriff's press release about weekly, nothing. So the county is quite frankly behind on this. It was a 30-second interaction, and it's very clear how he died. But without that coroner's inquest, the DA cannot decide whether to press charges or not. So we had a letter writing campaign. I'm also coming on today to announce a lighter event, a social justice fair that we're having Saturday, February 19th at Danville Congregational Church, a primarily in-person event. We want to build community. We want to have outreach efforts. Any of you who have organizations, you're invited to come and table. We would like to share more information about what we've been doing and what we need to do, especially in March. So yeah, thank you again for having me tonight. I think I see Nichole, if I can take a question.
Yeah, just really quickly, what happened with the decision on whether or not Officer Hall would be allowed to be free still right now during this interim time? Nothing?
Yeah, so on the 7th. So they were supposed to do something on the 14th. Instead, they had just a really brief trial motion on the 7th, during which it was, I heard that the judge expressed some regret for not remanding him to custody because he was free. So he's been free since October. He's free now. He will be free until March. He is still being paid on administrative leave. So this is like, I mean, I have a sick joke, like the only way to get an 8-month holiday is to shoot someone as a police officer. Yeah. So it's so it's a travesty of justice. So thank you for bringing that up. I left that point out. So he's still walking around somewhere.
Oh, it's just terrible what's happening. So thank you so much, Veronica, for being active with that. And it's getting late, so we're going to wrap up. And I don't think we have time for any other last minute announcements, but please stay in contact with us. Shirley's asking me to correct her website, and I did. It's yesfairelections.com. Is that correct, Shirley?
www.yesfairelections.org.
Oh, .org. Okay. Thank you. Okay.
Okay.
Thank you. And we'll get that information out in our newsletter. If anyone needs to sign up for our newsletter that I send out maybe twice a week, you can email president@srvdems.org. I'll put that in chat. And so thank you so much, everyone, for being here. I hope you enjoyed our meeting. And thank you to all the participants and extra speakers. We really appreciate you coming and letting people know what's going on. So thank you very much.